Welcome, Eneida Roman. I am
Thank
Josefina
you.
Bonilla with the Roar webinar series. I'm so happy to have you join us today.
Thank you for inviting me.
I'm happy you're here. You are a interesting person because you're an attorney, you're an entrepreneur, you're a founder, you've done so many great things. Let me have you talk just a little bit about yourself, introduce yourself and your company.
Of course. Well, thank you, Josefina. Thank you for having me. It's exciting to be here. We all need a little bit of distraction at this time that we're all going through. So thank you. So just about me, very, very quickly. I'm an attorney, as you mentioned. I'm the founder of Roman Law Offices. For the last 15 years, I've been an entrepreneur, founding my own practice. And my primary areas of practice are estate planning, real estate, and family law. And so I also help in that capacity because so many of my clients have small businesses. I help them sometimes with their small business transactions, but it's been kind of like a very organic way of doing business. As you know, you've known my business for a long time, and so you know the way it operates, right? Somebody comes in and they ask for one thing, and then they need something else, and for instance, a very easy example would be somebody who is going to buy their first house and they want to hire me for that transaction, and then they're going to get married, so they want to get a prenup because they want to protect their assets, and then they have children, and then they want to get an estate plan because they want to protect their children. And so it's very organic and very natural, and so it's been my joy to help my clients in that capacity. As an individual, apart from my practice, I'm very involved, as you know, in the community, and I'm co-founder of Amplify Latinx and Latina Circle, which are focused on elevating Latino presence and amplifying Latino voices, and essentially focusing on building economic and political power for Latinos in Massachusetts. And of course, beyond, because our influence goes beyond Massachusetts, but our focus really is in Massachusetts.
Today, however, we're just going to stay in the space of estate planning, wills, and trust. And to your point, I am a huge fan of yours. I've also been a client of Roman Law. Uh, and to your point again, I initially contracted you for one thing, and then we've done a variety of different things together. But as I think about, this is a perfect time as we are sequestered at home, thinking about our lives, the people that are important to us, and how we protect them. And so I want you to talk about why you should have a will and some of the elements that you would put in a will.
Right, right. So, the way that I frame this to my clients is essentially that, a will, we invest in so many things, right? And so a will and an estate plan has to be looked at as an investment in ourselves and in our families. And what happens sometimes, unfortunately, is that um, clients come to me and say, oh, my father passed away, my mother passed away, my spouse passed away, and he or she didn't have a will. And so that really complicates matters because it actually turns into a probate process, right? Which means that you have to go to probate court to explain that your significant other or your loved one didn't have a will, provide information on all the potential people who can inherit from the person who passed away, and so it's just very complicated and very expensive, really. And so it's actually an investment when you spend the money ahead of time so that your loved ones don't have to go through the heartache and the complication that represents going to court to deal with an intestate matter, which means somebody who dies without a testament, without a will.
Yes, I think that, one, if you put a will together, you're being really purposeful. You're uh, really telling everyone what you want done with your assets.
Right.
And I think that that's important in respecting yourself and respecting your family, because there's, you know, beyond the heirloom pieces, there's other things of personal value, sentimental value or otherwise, that you want to protect, and you want to be able to give whoever it is. My, if, for example, for me, my boys, um, you know, having what I want for them protected um, is important.
No, your point is incredibly valid, Josefina, because what happens is that when people pass away without a will, it creates a lot of confusion, a lot of problems for the family, and so it could potentially uh, just evolve into a horrible fight among family members, which would be unnecessary. If a person is married, at least here in Massachusetts, everything goes to the spouse, right? But if they're single, if they're divorced, if they they're widowed, and then they have children and they never had a will, that's where things get really complicated, right? Because
Oh,
yeah,
sorry, Anita. So let's say I get married, right? I have whatever I have, my house, and I want to make sure I leave that to my boys.
correct.
I don't do a will before something happens to me, right? So that means that the person that I just married has access to what could be my children.
Not necessarily, no. um well, yes and no. So let me clarify. So um if you let's say you buy a house and your house is paid off, right? And you pay everything yourself for that home, like all the taxes and everything, then that house is outright is yours, and then if you don't have a will, it will be your children's, right? But where things can get tricky is if you are a younger person, or maybe a person who recently bought a house,
Nina,
and
I'm
then
a millennial. What are you talking
yeah,
about?
that's right. We're millennials. So let's say that your house, you bought it recently, you get married, and then your new spouse helps you pay for that mortgage. So in theory, whatever value the property acquires during the marriage is a marital asset.
And can you change that around if you have a will?
Well, yeah, I mean, then you could protect your children because that's what I'm saying. If you don't have a will, then potentially your spouse could come, to the probate process and say, okay, fine, I'm not an heir, but I contributed to the value of the property, so I should get part of whatever value that property has. Okay. So I'm not saying that would definitely happen, but there's a possibility. When there's money, there's always fights.
Yeah.
Unfortunately, that's a reality, right? So that's why these things are so important, to just protect the people that you want to protect, and make very clear with the people that you maybe love, but maybe have other assets, and they can do their own thing, right? They can protect themselves another way. Another way to prevent this from happening is to have a prenuptial agreement. And I think we're going to get a little bit
Yes.
into the woods here,
Yes.
right? Because if you have a prenuptial agreement, then you're already saying, this is my house, it
Yeah.
will be my children's house, it's not going to be anybody else's house, and sorry guy or sorry gal, I'm not sharing with you. But at the same time, I mean, and not to get into details of how to manage a marriage when you have a prenup, but when there is a prenup, couples have to be very conscious of having, of the payments being made by the party who owns the property, because you could potentially at the same time say, the spouse, right, could potentially say, well, actually, I put money towards that, so you should give me some money. Not that they will own the property, but they will have some sort of acquired value there.
So we're going to talk about prenuptial agreements as well. Hopefully, we'll have time. But let's get back to money, and let's get to when you have children. For example, I'll be honest, this week, one of my boys is my favorite child. This week. Last week,
The other way.
candidly, it was different. right? And
Yeah.
so, and I have said to them at different occasions, I'll be honest, I'll say, you're my favorite.
Depending on the day.
It depends on the day. And so if I don't leave a will, right, there's these communications that I've had with my children, and half of this I'm joking around, but there's conversations we have with individual people, right? And those conversations, nothing can come out of it unless you have a will.
That's right. That's right. We have a saying in Spanish, las palabras se las lleva el viento. That means, the words are gone with the wind. So unless it's in writing, it's not enforceable. A person cannot go into court and say, my mom said that I was going to get this bracelet. No. Or my mom said I was going to get this ring. No. You need to make sure that you outline that in a will and make sure that you say, so and so is going to get this, so and so is going to get that. They are really valuable assets that you have, and things that have sentimental value, and that heirlooms that are family passed from one generation to the next. You really want to make sure that you outline. You can't just leave it to, because then the worst case scenario is that somebody in your family, because this happens a lot, somebody in the family raids your house, takes everything of value, and then who can prove that that was there or wasn't there,
Exactly.
right? And who can prove that they took it or didn't take it? So it's
So
important that
when you write a will, who keeps it? Your attorney, yourself, and do you have another place where you have it?
well, I always keep a copy, and I give my client their will, and I ask them to put it in a safe place, but I also ask them, so every will, every document, so and by the way, a will, I always use the term estate plan, because a will alone is not sufficient. You want to make sure that you have a will. You want to make sure that you have a power of attorney, because a power of attorney will protect you in case of incapacity, right? If you get sick and you are bound to a bed and you can't make decisions for yourself, and somebody has to go to the bank, you need a power of attorney.
Right.
Okay. And then you also need a healthcare proxy, because the same way, if you cannot express to your doctors how you wish to be taken care of, you have a person who will be making those decisions. They will have that power. They will be your agent. Okay. And so that person or those people should also have copies of those documents, so they know what your desires are.
So there's two questions I have. One, what type of things do you put in a will? Can you
What type?
put, for example, can I put my, not that I have them, but my season tickets to the Red Sox? Can I put that in my will?
Yeah, of course, you could put that in your will. Anything that has material value, anything that has material value, that is tangible property.
Okay, okay.
Yeah.
So,
Real or tangible, right? It could be real estate. It could be just physical, like a car. It could be something you collect. It could be jewelry. It could, anything of value.
okay, okay. So once I go to you and I say, let's work on my will, because I want to talk about estate planning separately, and we'll go to that. Once I have my will written, um, and my attorney has it, but say I move to Florida or to Puerto Rico, and you're not there, something happens to me, who's gonna know about my will?
That's an excellent question. That's an excellent question. So that's why you should always have additional people that know about it. You should tell your heirs. You should definitely tell your heirs, and you should tell them. I mean, I always advise my clients to be honest with their heirs, right? And tell them, listen, I drafted this will. I executed it. I have my attorney has a copy. I have a copy. I give a copy to so and so that they know there's transparency, so that nobody tries to fool anybody, right? So that everybody knows there's a will somewhere. Okay. And the question about jurisdiction is an excellent question, because laws are different everywhere, right? So if you draft a will here and you end up moving to a different jurisdiction, my advice is always to consult with an attorney in that jurisdiction to ensure that the will is valid, and that they can and that it would be able to be executed at that location, right? So for example, the question about Puerto Rico's laws are different than and other countries as well. And I'm glad you asked that question, because I have a lot of clients who have property outside of the United States, because they're either from a different country or they made an investment somewhere else. And I always give them the same advice. I tell them, listen, if you have property in a different jurisdiction, in a different country, anywhere outside the United States, we need to ensure that this will is aligned with any will that you have in that jurisdiction, because what's going to happen is that, or what could potentially happen, which hopefully wouldn't be the case, is that the wills, they can invalidate each other, right? And so you need to make sure that there's mention in one will about the other, and vice versa, so that when you go, or when your family goes to the country to probate the will, excuse me, the estate, they can make reference to the will that you made, in the other jurisdiction where you live and where you have property as well.
That's that, I hadn't thought about that until we're talking, because I know Puerto Rico has very specific laws around inheritance, and
Yeah.
particularly inheritance of property. As if I'm not mistaken, it doesn't go necessarily to your spouse, it goes to your children,
Yeah.
right?
But the spouse also has a lot of rights. So it depends, right? I mean, but Puerto Rico law is based on the Spanish civil law, and in the United States, the law here is based on the English common law. So so it's a little bit different, and you just always want to make sure that you have advice from local counsel to ensure that you are meeting all the standards, in each one of the jurisdictions.
Okay, so now walk me through estate planning, why you have that, how the will fits into all of that, and when do you start thinking about that? Because maybe you think, oh, I just have my house. Is that enough to actually have an estate plan?
Yeah, I mean, of course. I mean, I think anybody who has an asset should be thinking of estate planning, because again, it's about an investment. It's about preventing problems for your loved ones. And the problem is that, on top of the heartache of losing a loved one, the family members are going to have to go now into court to submit all this evidence that is really unnecessary, and I say unnecessary if you have the estate plan, right? Because if you have an estate plan and if you have only a will and not a trust, you still have to go into court. But all you do is you bring in the document, you tell the court, this is the will, give me permission to follow the directives of the will, and boom, bam, boom, and it's done, right? But but if boom, bam, boom, right? But if you don't have a will, I mean, it can be a long, drawn out process, and it is just, I mean, it's expensive. I mean, it's much more expensive than the actual probate, excuse me, estate planning process, right? Like, getting your documents in order is a certain amount of money. Going to court it's like 3 or 4 times that, right? And so that's why I always advise my clients. I tell them, listen, I understand nobody wants to think about death. Like, that's a topic nobody, you don't want to think about the moment you die, but if you really are focused on safeguarding the interest of your loved ones and want to save them heartache and want to save them, from going through hardship beyond the moment that you pass away, having an estate plan is a way to make them, to give them peace of mind, right? I mean, I think that's the
And,
easiest way
and
to
you
put it.
can change it constant.
Yeah.
You can
No, in fact, you need to revise your plan every 5 years because life changes, right? You could be married yesterday and not tomorrow. You could have, not have children yesterday, have children tomorrow. So that's a huge consideration. Another huge consideration I always tell my clients they should think about, especially people with small children or children under 18, is that, in an estate plan, you can appoint a guardian for your children, right? And so that can become a huge point of contention in families if say you have the maternal grandparents and the paternal grandparents, and it was like you said earlier, right? Because family members talk, and then the both parents pass away unexpectedly, and the children are left without parents. The paternal grandparents are going to say, our son wanted us to raise the kid.
Yep.
And the maternal grandparents are going to say, no, our son said, I mean, our daughter said that she wanted us to raise her kid. They're going to go into a huge legal fight now after the parent. And so imagine the suffering of the children. The grandparents are fighting. You know what? Just keep things, just put your affairs in order. Tell people this is who's going to be the guardian. And even if you don't tell them, you have it in writing, you have an executor who's going to be in charge of that. You have a person, you have an agent who's going to know what your wishes are, and they're going to say, you know what, so and so said that this the aunt is going to take care of the child, the godmother is going to take care of the child, the friend, the grandmother, the grandfather, whoever it may be, but it's in writing, and there's no question about the wishes that you have for the well-being of your children.
And for I know for Will, I recently had a friend ask me if something happened to them, if I would be willing, and I'm smiling because I thought it was kind of funny, willing to take her cat.
Oh.
And I thought, what? So those are things that you can have in a will. But I want to talk about the process of an estate. What
Okay.
things you can put in there,
Yeah.
and why would you?
So, okay, so an estate plan includes a battery of documents, okay? So it includes obviously the will, which is your last will and testament, and the wishes that you have for so who's going to have what from your property. It includes a power of attorney
Okay.
that essentially a power of attorney, what it does is that it gives another person power to handle your financial matters in case of your incapacity.
Now, is that different, Eneida, than the person that manages the will? The
Yes, yes.
it is
It,
different.
well, it could be the same person. It could be the same person, but it is so the person who manages your will is your executor.
Executor. Okay.
Okay. The person who is in charge of the finances, if you get sick and if you're bedridden and you can't make decisions for yourself, is your agent, is your agent for your attorney, in fact, if you will, right? The person who you appoint to go to the bank for you, to make your car payments, to make your mortgage payments, to make sure that your insurance, your life insurance is in order, that handles everything that's legal.
Can they enter into contract as well?
Yes,
Okay.
totally,
Okay.
absolutely,
So they're basically acting as you
correct,
in all things
correct.
financial. Okay.
Correct. So it has to be somebody you trust with your life, obviously, right? Somebody who knows your affairs. Um,
Can you take that away?
of course,
Okay.
of course.
I'm
Yeah.
just walking through. So you've got the will, you've got the power of attorney. What else do you need?
And by the way, and just to be clear, the power of attorney is only triggered after there's been certification by a doctor that you are unable, incapable of functioning, right? So it's not like you're signing this document and you're fine, and all of a sudden your sister has power over your affairs. No, that's not the way this operates. This only is triggered if in the case of your incapacity.
Okay.
Okay.
Okay. That's really good to know.
Yeah. Yeah. And so then another document that you include in the packet is a healthcare proxy, and that document essentially, again, you're appointing an agent, somebody who will make medical decisions for you.
Okay, so power of attorney is financial, the healthcare proxy is medical.
Correct, correct, exactly. And then there's another document that I typically include in the packet, which is called a living will. And a living will, essentially, it's a document where you give directives, you give medical directives of like what you want to happen in case of let's say you're brain dead and you're not functioning. So you may want to write, listen, I don't want to be resuscitated, disconnect me from all devices if I'm if I'm for all intents and purposes dead. That's where you also include organ donation, right? You say, I want to donate my organs for research at the moment of my death, etc.
And you can also have yourself frozen.
Good. You could, yeah, yeah, yeah.
We can be like
Exactly.
Disney.
If you have the money to do that.
No, it's really good to know that. So the will, which is who gets what, the power of attorney, the healthcare proxy, and the living will, which
Yes,
kind of dictates how you intend to live if something happens.
of
That
course.
will happen.
Of course, and then also as part of that, I include a a guardianship document because you do mention the guardianship in the will, but I prepare a separate document for the children, right? So where you're saying essentially, I want my sister X to have guardianship of my children, and if my sister X cannot have guardianship, then Y, right? And so every document that I draft has two alternatives, right? It has the first person and then the alternate in case the first person is unavailable and or something happened to that person. So you have to bring an alternate to do that. So again, it has to be people that you trust. And normally, um, I, a lot of my clients they have the same person, right? As long as that person is interested in doing it, they appoint the same person. There's also professional people who do this. So they that's what they do for a living, and you can put I want a professional trustee or executor to handle my affairs so that no person in your family has to do that. And so the payment for those people, sometimes that can be an attorney, or it can be somebody, your attorney or somebody else, and then that that person comes in when you pass away, and they handle your estate.
Now, within these documents, is that where you also kind of talk about, for example, for me, I wanted when I did my will, I wanted, and at the time the boys were little, so who they were going to stay with, who was going, but I also had in there their education and how that was going to be paid for. Is that part of the estate, or is that?
Yes, of course. That's part of the will. That's part of the will. Yeah, that's part of the will. Yeah, because you include like how you wish to use the money for what you want to use the money and how you want to use it, whatever monies you have.
And Ada, if, for example, you owe me money in the will, can I address that, or in the estate?
So the estate can take care of that. So the executor of the will look at the monies that people owe you, and they can go after them for the monies they owe you, because then they would owe the estate at that point. It would become the estate of Josefina Bonilla.
And I would have that all in my estate
Yes.
plan. Okay.
Well, I mean, you might not have it all in the estate plan, but if you have, let's say you have a company, right? And then people owe money to your company. That your company is part of your estate. So then the estate can go after the people who owe you money for sure.
As a matter of fact, I think when I did my will, and at the time I still had my company, my old company. I talked about how it would be sold and the
Yep.
proceeds of the sale,
Yep.
how they would,
Yep.
and that's how I set up
Yeah.
my how my company would be dealt with.
Right. So it's interesting because I'm actually going to have a webinar coming up with Juan Carlos Morales, precisely about what to think about when you're a small business owner, and the succession planning, and all the items that you have to put into place to
Hmm.
ensure that these businesses are in a safe place in case that anything happens to you.
Oh, that's so important, because as I think about my new company, Right Media, I'm just growing the company, but the company that I initially had, if it went through sale, then how the money would be distributed and all that great stuff, and who would inherit. But that's all part of the estate plan,
Yeah, yeah,
right?
exactly. What one more thing that I, like in the recent years that I've included in estate planning is directives for all our digital information, because that's something that many people don't think about, right? And so how do you protect your digital footprint once you're gone, right? And so there's another document that I create to protect that and to give the authority to a third person to manage that for you. So our LinkedIn page, our Facebook page, our Instagram, our, anything, our, websites, I mean, anything that you have that is digital, how is that managed once you're gone? And
So
so
in a document like that, would you include passwords and usernames and that sort of thing?
correct. So you, I mean, I don't tell my clients to put all that in one document, but I do ask them to give access to, to once they're gone, to give access to the people, perhaps if there's like a master password that you have, like, if you have a password keeper and you have a master password, and or the access to your computer and whatnot, so they can access all that information.
Well,
So I mean, but it's critical. Yeah, it's
I hadn't,
critically important to think about that, because we do everything digitally right now.
that's so important. I had not even considered that. Because you're right, your LinkedIn page lives beyond you, your Facebook, your all these other accounts that you either have to shut down, or depending, I would assume that if you're a celebrity of some sort, then that stays on in a different way, and that would be part of your estate plan.
Yeah, exactly.
Interesting. That is a new one for me. That's excellent. So let's jump into trusts. What are trusts? When do you need them? And before that, I will tell you an interesting story that made me think about trust in a different way. I had a neighbor when I lived in Brookline, and she had a long-term relationship with her husband, and then they decided to divorce. And he found out that he didn't have access to the house that they lived in for 20 years because her mom, as a gift, gave it to her at their wedding and she, instead of handing the keys over, she put it in a trust, and it protected the daughter when she got divorced. And at the time, she was angry with her mom that she put the house in a trust. But during the divorce, she was so grateful because nothing could happen to the house.
Yep. Yeah. Exactly. So that's an excellent example. So I mean, so people, when people come to me and they ask me, they say I want an estate plan, and so the first thing, we talk about is what they own, what their vision is for their life, what they, if they have kids, if they don't have kids, and so it all depends on what your estate looks like, right? And so normally I recommend people to have a trust if they own like significant assets, right? Like if they own a property, if they have money invested, if they have perhaps a business, if they have different kinds of accounts that they want to fund a trust with. And so and I use the term fund very intentionally, because um, they could create a trust with me. So they say, Eneida, I want a trust. I want to create the Josefina Bonilla trust, right? And so I drafted and I put all the assets, in on paper, right? But the trust needs to be funded. And what that means is that you need to transfer the ownership of your house to the trust. You have to transfer the title of, like whatever accounts you have, they have to be named like as part of the trust, because if they're not, then the trust is not funded, right? So then it's almost like an invalid document, because it's, you spent money to create it, to draft it, and you executed it, but you never funded it. You never transferred your assets to the fund, to the trust. So in your friend's example, what probably happened is that the mother probably already had a trust, right? A family trust. And so she purchased the property under the trust. And so the house's title, instead of having her and her husband, is named, family trust.
Mhm.
That's the title holder. And so if anything happens, then the property was always going to belong to the trust. And
So,
so
so if you create a trust and you don't fund it because in between you creating the trust, you pass away
mhm,
and it's not funded,
mhm.
can your, how would that work? Does that mean it's no longer?
I mean, I guess you could make the argument, and you could, fight in court, and go to to a tribunal and say, the intention of the decedent was to have this as part of the trust, but you would need to have a lot of evidence to show that, right? And you would, so normally the short answer is you might be out of luck. The house might not be under the trust. That's why, I always advise my clients, if you're creating a trust, you need to make sure that you fund it sooner rather than later, so that the trust is valid, so that the trust has significance, legal significance. Because another wonderful thing about a trust is that, how I mentioned earlier, that if you have a will, you still have to go to court and tell them, hey guys, I have a will, this is my will, these are all the documents, please certify that this is true and correct so that I can move forward with this, right? And even though it's less complicated than dying intestate or dying without a will, you still have to go to court. With a trust, you don't you your estate is completely private. Like, it's never going to be a public record that you have anything, right? Because it's going to be a document that protects all your assets, and you can pass your it's the trust has beneficiaries. So essentially, when you pass away, you might be the trustee, but when you pass away, the trust takes over, and then the beneficiaries get the assets from the trust.
Now, can you create a trust where it's in perpetuity? Meaning,
Yeah, I mean, you could, if you have that much money, you could. Yeah, I mean, technically, a trust lasts as long as the assets have value, right? And so if you have, if like for instance, that's why the grandchildren of the Rockefellers and all those people are called trust fund babies, right? Because there was a family trust that was created, 100 years ago, and there's so much money in that, because the money keeps on coming in, because they have businesses and investments and all that, that in theory, every time a child is born, that child becomes a trust fund baby, and that child's child, and so on and so forth. So yes, as long as there's money in the trust, as long as there's value in the assets that are named in the trust, yes, it could last for a long time.
how about, Eneida, if you have your house in trust and can you put in there that the house is, when you pass away, it's your child's, right? Or, and then it's my child's child. Can you do
So
that?
I mean, so I mean, you could potentially do that. You could say, like, but in theory, once, or typically, right, once that house passes on to the beneficiary, they have control of the asset, right? I mean, you could
Can they sell
put
it?
some. Excuse me.
Can they sell it?
Well, I mean, it depends on the person, if they want to sell it or not, and it also depends on certain restrictions that you might have put as the original trustee, right? So it all depends. It all depends. It
I
depends on the
think
person.
that's probably the most exciting one for me. Like that is this idea that I worked very hard to have this house, for example, or my company, and when I go, I want to make sure that all that stays in one place
Yeah.
and it stays beyond me, almost like a legacy, right? And that's where you would use the trust.
And it also depends on how well, and again, we're getting into the weeds here, right? Because it's not so
Yes,
much about
yes,
estate
yes.
planning, but it also depends on how well the trust is managed, right? And the assets are managed. Because let's say that you did have a business and you wanted it to pass on to your children and then their children's children, but then your children mismanaged the business, and or even if they managed it well, there was some sort of crisis like what we're going through right now, right? And that impacted the viability of the business. and then the business cannot continue existing, right? So even if you had the wish, even if you wanted this to exist in perpetuity, it's really not going to be viable at maybe at some point. So it just depends on the circumstances. But yes, I mean, you can, that's why, when I sit down, I always ask, what is your current situation? What is your vision? What do you see? What do you want your child? How do you see your children in the future? What do you want them to have? And also I work a lot of times hand in hand with financial planners, right? Because if my client already has a financial planner, then I work with them to make sure that everything is aligned, right? And by the same token, if they don't have a financial planner, I usually tell them, well, you might want to find somebody who is an expert in this space, who can give you, who can guide you in the financial aspect. Because I'm not a financial planner. I mean, I'm an attorney. I know how to draft documents. I know how to create an estate plan, but I'm not a tax expert. I'm not a financial person. So I would, advise them to go to a person with the necessary expertise, so that they can, move their assets whichever way they need to.
Hmm. So I think when you're thinking about the will, it's this one small document where if you think, more of thinking about it, as you said, as a whole, then you're thinking more of the estate planning, which is all those documents together. So I'm trying not to say so. I feel like I'm always saying so. Um, but Eneida, when somebody goes to see you, what should they have already together? So your time with them is the best use of the time that you have.
That's an excellent question. So before I meet with my clients, I send them a questionnaire. Okay, because that way they're prepared when they meet with me. And so this questionnaire is pretty thorough. It essentially asks you for all, your personal information, your assets, anything that has value that could potentially go in your estate plan, who your potential heirs are. I even ask about charities, right? Because there's people who want to leave money for the causes that they believe in. So, if they have any particular NGO, nonprofit organization that they wish to, or even if it's not an NGO, right? It could be, I want to leave money to a friend. I want to leave, anything, right? I want to, I have a friend. I believe in my friend's business. I want to invest in that, so I want to leave money for that. And so they, it depends. I mean, there's so many. I've seen so many different things, and it's fantastic, right? Because it just shows the values of the people, right? That you're working with, and it demonstrates, where their priorities are. And so that document is going to reflect what your priorities are, and it will outline what your assets are. So when you come and meet with me, you already have an idea of where you're coming from and where you want to go. And so the conversation is around, obviously, that document, but also around what they visualize, because depending on what they visualize, they will only need the will and the rest of the documents that are part of the estate plan, in case of incapacity. But if they have much more that they wish to protect, then they will also have a trust. And trust, trust. And in Massachusetts, I mean, the interesting thing is that in Massachusetts, anybody could have a $1 million estate, because properties here are so expensive that, you're a millionaire, and you don't even know it, right? Because between your life insurance, between your investments, between your house, and anything else that has value that you own, you could easily have a $1 million estate. And so at that point, I recommend a trust, because in Massachusetts, there is an exemption up to $1 million. And so if you have a trust, and I don't want to go into too many details, because I will be here for 2 hours, but essentially, that will help protect the state from taxation at the time of your death.
Which
Okay.
is really so important because I think there is that too.
Oh,
I
it's
know that
it's
this is not what we're gonna spend our time, but that is a factor. When you leave property to someone, they also have to be unfortunately, they're going to have to pay some taxes related to what you're leaving them.
Well, the spouse, there's an exception for spouses, but everybody else does have to pay. And then and there's also the estate tax, right? So in Massachusetts, there's an estate tax between 0.8 and 16%. So I mean, it's quite, that's, I think that's why they call Massachusetts Taxachusetts, right? Because I mean, there's a lot of, there's a big, so that's part of the estate planning, right? That's part of you organizing yourself so that the estate doesn't have to pay not only your beneficiaries and your heirs, but also the estate not having to pay the taxes. Because let's say you have, $1 million, right? Out of that $1 million, you will have, the estate, before it can be distributed, the state will get paid before anybody else gets paid. So, and you have to file the state taxes within a 9-month period after the person passes away. So all of that is part of the planning, right? Making sure that you minimize the tax liability, making sure that your loved ones are protected, making sure that you also protect yourself, for long-term care. So that's why I always, suggest that people talk to financial advisors, because they can purchase, long-term disability insurance, regular life insurance policies, and things like that that give peace of mind to you, in case of, like, for your family, give you peace of mind now for the future of your family, in case that you're not here in the future.
Like we talked about, Aneda, oftentimes we have conversations with people, right? And those conversations stop there, because unless you have it in writing and your
Nada.
wishes are clear in black and white, the court doesn't care. And it's hearsay.
Exactly. Another reason to create an estate plan is, excuse me, a trust, is many times when people have children who are disabled, right? And you are concerned for the future of that child. And so I mean, for most people, it's their children that drives them, right? To make sure they put their affairs in order. But especially people who have children or a child with a disability, so they want to make sure that they leave a trust in place for that child, so that that child is taken care of once they're gone. Because I can imagine that's the biggest fear of any parent, right? That if they have a child with a disability, who's going to take care of my child once I'm gone?
Super. I'm going to open it up to see if anybody has questions. And Neda, this is great because I wrote down so many things. I definitely need to update my will, but more importantly, I really do need to now put things in an estate, and possibly, I do have a fish now. I don't know if you can see him. Beyond my children, somebody else to take care of. I'm just being facetious. Do you have anything you want to share before we close off?
No, I mean, I just want to emphasize how important it is to make sure that people see this as an investment, because it's an investment in you, it's an investment in your family, and like, it's sometimes we don't want to think about the negatives, but we have to make sure that we protect our loved ones, and so this is a sure way of protecting our loved ones.
No, and I think it's so important. I'll when my oldest brother passed away, he did not leave a will. And so we were left with just figuring out what he wanted. And it was one person's interpretation of what he wanted, because my conversations with him were different than my siblings. And so I interpreted that he wanted this or that. Where had he had a will, then he would have gotten exactly how he wanted. Um,
And you make a very um, convincing point, right? Because in the end, it's about dignity, And in the end, it's about, respecting the wishes of your loved one who passed away, right? And what better way to, to have something in writing and to make sure, what, these were Josefina's last wishes. So we have to honor them and we have to respect her and we have to let her legacy live through her wishes.
Love that. Eneida, thank you so much for joining us. This is great information. I definitely, again, I'm going to work on my estate plan and maybe a trust, um, because I think they're important, and this is the right time to be thinking about it. It's never, you never want to think about it, but this is the right time to.
And especially, yeah, especially now that people have hopefully a little bit extra time on their hands, and they can make time for, for self-care, right? Because self-care is not vanity, it's not selfish, it's, it's just being responsible for yourself, and it's knowing how to love yourself in a way where you can be remembered nicely and positively, right? Because the worst thing is, I mean, I've seen so many families go through this trauma of infighting, of, and this lasts decades. This could last, like 10 years, maybe longer, when families are fighting over assets and or decisions that, that could be easily avoided if there's an estate plan in place.
Exactly, exactly. And Neda Roman, thank you so much. And this was great information. And thank
Thank you.
everyone for joining us at the Roar Daily Webinar Series. Thank you.
Stay safe. Thank you. Bye bye.